Hello, everyone. This is Professor Roberto Ramirez. This is for International Business Law for week 6. Thank you for joining me. I know this is generally an in-person presentation, but due to some issues with the family and there was a death in the family, so we're not gonna do in-person class, but I'm gonna post this video so you can watch it. Again, this is week 6 for International Business Law. During this presentation, we're going to go, I'm going to go over Chapter 7, which is the international sale of goods. Now, in order to, I believe and I recommend, in order to go to better understand this video, it would be probably best for your benefit to read the chapter and then come back and watch the video. And then once you're watching the video, once you're following along, I think everyone knows everything will flow a bit more smoothly, and you'll be able to grasp the subject matter much better because you've already had a taste of it while you read chapter 7. Also, this presentation is already on Blackboard, so I urge you to, while you're following along, you can have the PowerPoint available to you. You can electronically, or you can print it out, so you can follow along with me and everything that we're saying. So this slide, this presentation, it shouldn't take more than an hour. It's I believe 18 or 19 slides. We'll discuss Chapter 7, especially the CISG, which is the international sale of goods and the contracts that go along with that, as well as I'll touch a little bit. I know we touched on it in last class, but I'll touch a little bit more because it's very important and a big part of your grade. I'll just go through one more time to make sure everyone knows, unless in case they were absent for last class, we will be doing a paper on a foreign country that you all have chosen, and we will also be doing a presentation on that paper. So with that, there are you'll see on the next slide, there are some people who changed their countries. So as you see, I'll have the individuals with their country names on there. Also, I believe there's one or two people who are still pending a country. If you can email me as soon as you can, as soon as you decide, so you can let me know which foreign country you're going to do your paper and presentation on. That way I can update it. But let's just discuss real quick on the next slide the presentation paper and the paper and the presentation, so you guys can actually see it, go through it again, and again ask me any questions you have on it, because once we get closer to that presentation date, it's going to be I'm sure I'll get more questions, and I'm not sure if I'm going to be able to respond right away because I'll get more questions. But if you do have questions, the earlier the better. Make sure it is the country that you chose, and then start researching already, because I don't want you to, everything's going to pile up toward the end. Finals, everybody's going to do finals, so I don't want you to be writing the paper, focusing on the presentation and the final and finals for other classes. So it's better to get started as soon as you can, to make sure you allocate your time accordingly. Okay, well, let's go to the next slide and talk a little bit about the paper and the presentation. Thanks. We're jumping on to slide number 2 of the presentation. In slide number 2, we're going to consist on talking about your paper assignment for the foreign country. Again, this what I'm reading, all these notes, you don't have to take notes extensively right now, because what the paper I'm going off of that I'm going to discuss is posted on Blackboard, so you guys can put it up. It's basically all the directions and all the information you need for the paper assignment. I'm also going to discuss some details about the presentation assignment, which is the same. The presentation is going to be on your foreign country that you wrote a paper on, but both of these documents are posted, should be posted on Blackboard. Which, no, I believe they are posted on Blackboard. So just follow along. If you can, review it. Let me know if you have any questions on it sooner rather than later. So one thing in the paper assignment, so the due date is going to be for the paper on Friday, November 15th. Excuse me. On that Friday, the presentations start on the next Monday. So I just want everyone to know it's getting pretty tight, but the presentation is due on Friday, November 15th. There are no late assignments. You guys are adults. There's a deadline that I'm giving you way in advance. I think it's a very doable deadline. Now for the topic, you're going to research and write a paper on a legal system of a foreign country that you select, which I already have the majority of the foreign country, the individuals and the country they've chosen. I believe there's maybe one or two. Those one or two, you can email me, let me know your country whenever you get a chance. Also, I believe some of you changed your country. You can look at the next slide and just make sure that I updated that for you guys. And then your paper is going to have to provide substantial discussion on how the law and the legal history and the legal structures of your selected country kind of impact or are impacted regarding the laws or the international laws that we've been discussing in class as well. The length of the paper, I'd put it here 6 to 7 pages. Try to stick with that range. It's going to be double space, 1-inch margins, 12-point font. You can look at that here on the paper. I put in there some library resources to help you write your paper, as well as writing help and on there. Now, some of the questions that you can consider when writing your paper, I gave 13 examples of them. I did say the other time, just fair game. When you're doing your presentation, these 13 questions, these are the ones that I may ask you. I'm not going to ask you all 13, but I may ask you 1 or 2 of these 13 questions. But I'll stick to these questions so you know if I ask you a question, I'm not going to ask you something from left field that you did not prepare for, you didn't research anything like that. It's just fair game. If you consider these questions and you know the ballpark, you kind of know how to answer these 13 questions, then you'll be fine for the presentation. I won't ask you anything out of the box of these 13 questions. Some of these things, what are the historical roots of your legal system? I know that's a broad question, but if you can maybe just touch on it, that'll be fine. I'm not looking for an exact answer. Is international business encouraged by your country? You can say yes, no, and a little example. That's fine. Are the laws of your selected foreign country, are they business friendly? I know that's going to be a subjective answer to what you believe the laws are based on your research. That's fine as well. I just want you to kind of understand and know a little bit about the country and the business environment they're in. How do you become a judge in your foreign country? You can just briefly touch on that. What is unique? If there is anything unique about your country's legal system, is there anything that you found out that is unique that you want to touch on? And then maybe one other one, number 13, is what did you find interesting? Something you found interesting about your legal system. It can be maybe a case that you research and you found out the way a certain country rules or has outcomes on certain decisions. It can be anything about the legal system, how judges are selected, if you think it's unique. Just something you found interesting that you didn't know before that you would just like the class to know and maybe remember. That's that's fine as well. And then obviously I just put a quick note that obviously you guys know all of the information on your paper. It has to be relevant to the discussion of the country's legal system and its impact on business and international business. So basic history and geography. I don't want that to be the bulk of your presentation, because that's kind of just background noise. That can be part of your presentation, but make the meat of it how the legal system impacts business and perhaps maybe international business or international trade with other countries. That's what I would like to see in the presentation. And then of course the last one, academic dishonesty. Please don't plagiarize your paper. You know that's not right, and you guys are adults. You know there's consequences to plagiarizing the paper. Okay, so I went over those. Those are the quick notes for the paper assignment. However, all of those, everything I just read, is on Blackboard. So please print that out and then know the directions that you're going to take for that. Now, also I want to go over the kind of some rules or some guidelines for the presentation. Now, I know I do have, when I discussed it last week, there are, I'm not sure if there's 2 or 3, but I have them there, 2 or 3 that want a specific order. We set aside 4 days for the presentations, but there was 2 or 3 individuals that said, I want to go first, I want to go second, I want to go third. That's fine. I did get those, so I'm going to just, out of those 3, then everyone else, I'm just going to select them at random, and then I'll give you the order of what the presentation, or who's going to present in what order. And then obviously mispresentations, once they're not acceptable unless there's an emergency and something huge happened that it was completely out of your control, then I can understand that. But anything like that, but please try to be prepared on on the day of your presentation. Now, for the topic, please share what you learned about the legal system, about the country that you researched. Things that you should cover in your presentation is the legal system of your foreign country. Basically, the roots of your country's legal system. Is it common law or civil law? And perhaps maybe one of the biggest things that I would want to see is there important laws that impacting business or trade with your foreign country? Please touch on those. Something else that you can research and find out is your country a WTO member? We went over the WTO. There's a lot of members. I just want to know if your country is part of that. And then one thing is what did you find interesting about your country, which is more business related or international business trade related. Let me know that. And then as well, on the paper assignment, there are 13 questions. Remember that I want you to maybe answer in your paper. But again, those 13 questions, that's where I'm going to get the questions to ask you during your presentation. So you can write on all 13 of those questions. That's fine. If you write on 3 or 4 of those questions, that's fine too. But the other 13, I just want you to know that's where I will be getting. If I ask a question, then it will be from those 13 on the paper assignment. Now, please keep the length of your presentation. Again, we have a lot of individuals presenting. We only have a certain amount of days. So if it's between 10, 12 minutes, that's fine. It's I know there's a lot of information I want you to cover, but if you're having trouble fitting all that, squeezing it into that 10 or 12 minute presentation, don't worry about it. I just want to know it's that your paper that you can kind of speak about your country, kind of give us a quick little summary of the foreign country and how it does international business or international business trade. That's fine. And then of course in the format, you're going to give a live presentation using a visual aid. Now your visual aid can be anything you want. I believe most people are going to use PowerPoint. That's fine. But any other format, I mean, that's fine. You're okay to use. Just try, again, I put it here, just try to not put the class to sleep. I'm going to leave it up to you guys. It's up to your discretion what you want to use. But again, those are the things I want you to know for your paper and your presentation. But again, both of those notes, those documents are on Blackboard. So you should be able to see everything I just discussed is on Blackboard. So, but let me know if you guys have any questions or comments or don't understand something I wrote on there. Please let me know so I can clarify that for you or I can answer that for you. But okay, but let's jump on to the next slide and let's talk about today's topic, chapter 7. All right, guys, I'm here on slide number 3. I just wanted to, I know we touched on this on last class, but some of y'all wanted to make changes to your foreign country. So on this slide, I did update. Hopefully, I did update those who wanted to update their country to a different foreign country. So this is what I have so far. Please check, everyone in class, please check that your name is on there because I know there's, I believe, 1 or 2 individuals who I don't have their foreign country selection for yet. So if you're not on there, perhaps if you did tell me, and I'm sorry that if maybe I missed it and I didn't put you on there, please just email me to remind me, or if you're not on there because you haven't selected one, if you could please do so as soon as you can. Let me know. Shoot me an email to just let me know your foreign country selection. Obviously, I would urge you or encourage you to try to make it try to your foreign country selection be something different than what someone else has selected. That way, you all don't conflict and that way we don't have to compare you to the other individual, and there won't be a winner and loser for who presented better or who had a better paper and presentation. But if you can, just pick another country. I know I don't want to give a deadline for picking your foreign country, but we're going to get closer into October, and then by November, I'm gonna start pushing the people who haven't told me yet a little bit. Your time is running out, so if you can let me know as soon as you can what country you'd want to write on and have a presentation on. Okay, well let's jump on to the next slide. Now jumping on here to slide number 4, we're discussing the international sale of goods, which was in chapter 7, but specifically we're going to go into the contracts, the international contracts. Now, as I'm sure you know, but contract law, it's going to elevate private agreements between two or more people or two or more entities, it's going to elevate them into a legally binding agreement. And that's of course the essence of a contract, is to make it legally binding. Now, from what you understand in this international business law, so international business disputes, generally revolving around contracts, they're going to involve generally a very predictable set of questions. First, they're going to say, did they even have a contract? Second, they're going to say if a contract is valid and established, then they're going to say if they had a contract, what rights and obligations did the parties have, or do they have? And then what rights do the parties have when some or all of the performance of the contract is substandard, or if it's non-existent? So what rights do they have if one party didn't fulfill their end of the bargain or their responsibility? If I paid them but they didn't ship me the goods, or flip the other way around, I shipped them the goods but they didn't pay me, what rights do I have? Obviously damages, breach of contract, everything like that. But they want to know, was there a contract? Second, if there was a contract, what rights and obligations? What are the terms of the contracts? And then third, if those terms are not fulfilled, what do I do now? How do I get whole again? So that's the majority of the main three questions you ask if there's ever any dispute. But let's go on to the next slide and talk a little bit more about contracts. Here on slide number 5, still sticking with the nature of contracts. Now, as you know, when both parties are from the same country, say both parties are from the U.S., they're governed by the same U.S. law. Now, even that judicial resolution, or that resolution in the court, if they file a lawsuit, we know that is often complex and time-consuming. There's even a lot of what court do I go to if somebody was shipping something from Texas and the buyer was in Florida? What if the buyer got the goods but he didn't pay the supplier in Texas, but the buyer in Florida says I didn't get what I ordered? So even that dispute, where do we file the lawsuit, in Texas and Florida? That is a long process with attorneys involved. It can be very expensive, very complex, and very time consuming. So then that's already dealing with two parties that are in the same country. So you can imagine how complex or demanding and time consuming it could be for contracts that are dealing with parties from different countries. Now imagine compound it now on these type of disputes or these type of problems that you're going to have already with the parties. Now on top of that, add, there's geographic separation, of course, separate where they're located. There's going to be language barriers. There's going to be cultural differences. And there's going to be, of course, large amounts of money involved in these transactions. Generally, these transactions aren't going to involve $1,000 or $2,000 or $3,000. They can be, 300 million in the billions for how much the actual transaction, the dispute is about. So all those things combined, for all these reasons, is why international contracts, they generally, and they demand a much greater demand in precision and caution if the parties hope to avoid this type of, economic disaster. So when attorneys or the companies using attorneys, in-house counsel or law firms, they're drafting these contracts, the amount of expertise and the amount of time and caution you use on these contracts is very, very extensive, because the repercussions, the damages can be an economic disaster when, of course, we're dealing with two separate countries trading in large amounts of quantities. Then and at the end, if there's any dispute, or someone's not getting paid, or someone didn't get the goods they ordered, or perhaps they didn't conform, they're not exactly what they ordered. At the end of the day, when there's ever in a dispute and you go to an attorney and you tell them an issue or a problem you have, the first thing the attorney says is, well, let me see the contract. Let me see what the contract says. So that's why it's very important that these international contracts are they're put a lot of attention is put into them to make them I would say bulletproof, but at least to the best of your ability to avoid this disaster that can happen if there's any dispute or someone is suing for damages. Let's go to the next slide and keep talking about this. Jumping on here to slide number 6 is and this is a big tongueful, is the United Nations Convention on Contracts for the International Sale of Goods, We'll just call it the CISG. Now, the CISG is a treaty that governs the international sale of goods. So it governs the sale of goods between another country and another country. It was adopted in the 80s, in 1980, and it went into effect in 1988. Now, the purpose of the CISG is to provide a modern and uniform and fair regimen for contracts for the international sale of goods. So it's a set of laws that's going to govern the sale of goods from a foreign country to a foreign country. So no foreign country's law is going to be supreme over this if they choose to be part of this. Thus, the CISG is going to contribute significantly to introducing clarity in or transparency in commercial exchanges and decreasing the transaction costs, because it's almost having a treaty where we all agree, the countries who are members, we all agree to abide by these rules that the CISG has on there. So it's going to be, anytime there's international trade, then everyone's going to abide by these rules. Contract formations, what makes a contract, what needs to be in a contract, everything is that. All the rules are going to be in the CISG. Now, the main goals of the CISG, I just put the four topics here, but what I believe is it's going to provide a uniform set of laws for international sales contracts. It's going to balance the interests of the buyers and sellers. It's going to offer a comprehensive set of remedies if there's non-performance, meaning if someone doesn't do what they're supposed to do, it's just comprehensive. It's going to say these are your options, basically, and it inspires the creation of many regional and national laws. A lot of these, your national laws or just state laws, for example, Texas, they can look at that and then they take pieces of that to make it into national or state laws as well. Now, according to the United Nations in 2020, there are 94 parties in the CISG, and together they represent over 2/3 of the global economy. So 2/3 of the world uses these type of rules to do international trade with each other. One thing, just to get maybe some extra points in the presentation in the paper, you can touch on if your country is one of those parties that adheres to the CISG when they're trading with another foreign nation. But that's just something I wanted to touch on. And the next class, if you did have questions, then we can go ahead and ask me that too. But let's jump on to the next slide and continue with the CISG. Now, jumping on to slide number 7, still dealing with the CISG. Now, the contracts for the sale of goods is going to be the backbone of the international trade in most countries, or I would say maybe all countries. Irrespective to their legal tradition or their economic development, they're all going to fall back and depend on a contract for the sale or the purchase of international goods. The CISG, therefore, is considered one of the core international trade laws in the world, which is it's going to be universal. Hopefully, most countries want it to be universal, adopted by all countries, that this is the law that's going to govern contracts when dealing with products sold from one country to another country. But right now, it is not the law that they have to adopt this. It is just if you're a member and you opt in to adopt this, then this is what you're going to be governed by. The CISG governs contracts for the international sale of goods, as you know, between private businesses from one country to another country. But however, it does not cover the sales to consumers or the sale of services. Those are excluded from the CISG. So any sale directly to a consumer, which is an individual, or contracts for services are not covered by the CISG. They're covered, of course. There's also some, we won't get into much, but some specialized goods that the CISG does not cover. But it's going to apply by virtue of the party's choice. If they want CISG to apply to them, then this is what will govern it. Again, 2/3 of the world, I believe I mentioned the other slide, 94 countries, so it's about 2/3 of the world's that trades in the world, that they're all governed by the CISG. So I'm short to say that it's most of the world, but it's a lot of the world that uses the CISG. Now, there are going to pay to certain matters relating to international goods. They're going to fall the validity of the contract. That's going to be CISG is going to cover the validity and also the effect on the contract. Also, parts of the CISG is going to deal with the formation of the contract, specifically if there was an offer and if there was an acceptance of that offer. That's something that you look to CISG, which is very important when at the beginning of the dispute, was an actual offer made, or a legal offer made, a legal binding offer, and then also was a legal binding acceptance given. So those are things that we look at the CISG to make sure if those elements were met. Let's go on the next slide and keep talking a little more about this. Now here on slide number 8, for still continuing with the CISG, we're dealing with another part of the CISG. It deals with the obligations of the parties in the contract. Now, for instance, the CISG also deals with the obligations of the sellers, including the delivery of the goods in their conformity with the quality and the quantity that's stipulated or mentioned in the contract, as well as related documents about transferring the property in the goods. It's going to touch a little bit on the obligations of the buyer, including the payment of the price, as well as taking the actual delivery of the goods. In addition, this part is going to, well, the CISG in general is also going to provide common rules regarding the remedies or the options that you have for a breach of contract by another party. Now, the aggrieved party, the injured party, or the victim, we can call them, may require performance to make the other individual perform his or her responsibility or the responsibility of the contract. It's going to touch on damages, what type of damages that aggrieved party or that victim is entitled to, and it's going to also regulate if the party who perhaps maybe only got half the load delivered, they made full payment, but they got, if they can avoid the contract because it was such a fundamental breach, if they can just avoid it in general and just leave not paid or get all their money back. CISG is also going to touch on some additional rules to regulate the passing of the risk or the shifting of the risk or the liability. They're going to be anticipate if there's a breach of contract, what are the rules that are going to be governed, or the rules that everyone's going to follow if someone didn't do what they're supposed to do. And perhaps maybe there's also going to be some exemptions from performance of the contract, and some of those things that say, if there was an act of God which I was supposed to deliver a certain amount of quantity, but if there's no way to find it, if there's a pandemic that spread across the world and there was no way I could find workers, or the government shut me down, therefore I couldn't, my manufacturing company was shut down during COVID, the government shut me down, I can't perform the obligations, then perhaps maybe that's going to be in the contract, that there's going to be an exemption. If there's any government regulation that shut your business down, then perhaps maybe then you're not legally bound to still be to still have that contract be enforced against you when it's something out of your hands. So that's going to be in there as well. But let's go a little bit more into the next slide so we can discuss a little bit more about the CISG. Now getting on here to slide number 9 with the CISG, but we're going to touch a little bit upon the freedom to contract. Now, out of deference to the concept of freedom to contract, the CISG permits the parties in the transaction to opt out of the of its coverage or of its terms. So if there's a certain law, or if they don't like something in the CISG, certain nation can say, you know what, we don't want this transaction to be governed by the CISG. Again, it's something that countries want to adopt. It is not the law that per se of international trade, but since there's no nation that just governs everybody's international trade law, this is a treaty, a set of laws that individual countries adhere to, or say, you know what, we elect to opt in to these type of laws. However, in that there's also you can also opt out of its coverage. Now, the CISG doesn't specify any particular language or form for opting out, so it just has to be a country's, both of the agreements to say, we opt out of the CISG and we do not want to be governed by that law. However, as a general rule, the contracting parties, they're going to make their selection by including in their contract what we call a choice of law clause that rejects the CISG and designates a particular domestic law if they wish to have the transaction governed by that law. So, for instance, if the U.S. is trading with another country, with the Netherlands, then at that point, if the U.S. says no, we can trade, but we don't want to be governed with the CISG. We'll be governed by U.S. law. So if you want to sue us, you can sue us in the U.S. and the laws that are going to apply are U.S. laws for trading. That's something that the countries can opt out of, and one country can say, you know what, no, this law, this domestic law, our laws are going to be the ones that control because we know them better, we're familiar with them, that's what we want to happen. So that's going to be the choice of law clause. It's not always used, but some countries perhaps maybe if they have if they don't want to make the trade, they can use that as a negotiation tool. Also, in the flip side, now buyers and sellers, they can also opt in to the CISG in instances where it may not apply. So this would be accomplished with the same thing, the choice of law clause, designating the CISG as the governing law for the transaction. So again, there's a set of rules out there, not laws, but rules out there that two parties can say, you know what, we want to be governed by these rules. We both signed this contract, it's governed by that rule, and that's how they can opt in, even though the CISG wouldn't apply specific to their transaction. They can bring it in and make it apply if they adopt those rules. So that's just the freedom of the contract. Again, these are not laws; these are just rules, a treaty that countries can agree to be bound by, but agree voluntarily to be bound by. So they can opt in or to be glad, or they can also opt out and say, we don't want to be bound by that. If I'm trading with the Netherlands, I can say I want to be bound by U.S. laws, Netherlands. And then the Netherlands will also agree they'll be bound by U.S. laws as well. So that's opting in or opting out of the CISG. Let's go to the next slide. Now jumping on to slide number 10, with the CISG, what's specifically different or designating or discussing what constitutes an offer for under the CISG. Now, under a CISG, a proposal does not constitute an offer unless it meets 3 formal requirements by the offeror. It's going to have to be addressed to one or more specific persons. It can't just be an offer open out there. It has to be specifically for an individual or a group. It must be sufficiently definite, and then it's going to have to indicate the intention of the offeror, or the person making the offer, to be bound by the proposal in case of an acceptance. Now, it can be derived from this definition that in order to establish a valid or legal offer, 2 conditions must be present to be a valid offer: the intention for the offeror to be bound by it. So it's very clear that this is, I'm sending this and I intend to be bound by it if you accept it. And then sufficiently defined proposal. It has to be, in there we have to understand what the proposal is, and it has to be clear on what it is. So that's the intention to be bound by. If I'm the offeror, the person making the offer, my intention is to be bound by it. And then as well as we have to understand the substance of the offer, what I'm going to be bound by. Let's keep on the next slide. Keep discussing this on the offer. Now here in slide number 11, the sufficient or the definite part of of the offer. We know the first part is I have to send it to a group of individuals, and I have to be intended to be bound by it. It has to be clear that when I made the offer, I wasn't joking. I intended to be bound by the offer I was making. But the second part is the sufficiently definite. It has to be clear that the proposal is not, it's not just forever, and it's just unclear about what I'm actually offering. It's gonna have to identify the goods that I want to trade or sell, and has to specific on the quantities and the price, and it's gonna indicate the method for determining the price of whatever I'm trying to sell. So you do have to have the amount and the quantities and what I'm selling. Those have to be clear in the proposal, as well as my intent to be bound by the acceptance if the party accepts it. Another component of the proposal is the intention, of course, that the offer is the intent. Now, we can argue that if someone was making an offer, there was no intent. I would sell this pen to someone for $1, and someone said, okay, well, I'll buy it. Yeah, but it was, I can argue my intent was not to sell it to you for $1. It was not clear that I was offering it to you and that was my intent to offering it to you. So that's where it has to be clear that my intent was to offer it to you for these terms. That's going to be sufficient to make an offer. Now, sometimes an offer doesn't always have to be that what you would say like seem like a definite, a legal, very term proposal. It can be in the form of an invoice. You know, if I can invoice you, hey, I want to sell you this pen, I sell you an invoice to say I am my company pen, Professor Ramirez Pen Company wants to sell you this pen. Here's the quantity of the pen, the item, the detailed item of the pen. The price is for $1. Delivery date next in 30 days. And then if I sign that, send it to you, that's not a very long contract, a long proposal, but that's enough to justify an offer in just the form of an invoice, or perhaps maybe simple a letter of acknowledgement that I want to sell you these things, this pen. It can be a one-page invoice. In that that's going to be sufficient to define an offer under an offer in regards to the CISG. Well, let's keep on discussing a little bit more on this. Now, slide number 12, sticking with the CISG, but we're going to talk about withdrawals of offers and revocations of the offer. Now, in order for an offer to be withdrawn, the CISG states that the withdrawal should reach the offeree before or at the same time as the offer. So I think that we can understand that if we're making an offer to a party, we send the offer. However, before they receive it or at the same time they receive it, we send a withdrawal with it. Then of course we can say, well, the offer has been withdrawn. They got the withdrawal before they even got the offer, or they got the withdrawal at the same time. They get both of them. I made you an offer, but then also withdrew my offer at the same time. Then that's basically that shows that the offer has been withdrawn by the offeror, by the party making the offer. Now, I wanted to just point out that it's going to be noted that revocation and withdrawals, they're different. They're going to be distinct from each other, having different meanings under the CISG. Now, an offer is revocable when it reaches the offeree before the acceptance is dispatched or sent. So that's different. If an individual receives or a company receives an offer and well, let me think about it, I don't know, but then they receive a revocation to say, you know what, we want to cancel that offer, then the offer has been revoked. But that's different. It has not been withdrawn. Withdrawn means when the offer comes at the same time as the withdrawal. That's different. But when the offer has received the offer and it's with them, but they have not accepted it during that time when they're thinking about it, during that time, you may revoke the offer if they get it before they accept it. Now, in some instances, the offer cannot be revoked. Now, we can say if there's a fixed time frame, they say, you have 24 hours to accept our offer or it is going to be revoked. Then they send that 24 hours. They cannot revoke it in that 24 hours. You can't get a letter say, hey, do you want to purchase this pen for $1? I'll give you 24 hours to decide, and then it's going to be revoked. Within those 24 hours, I can't send you a letter saying, never mind, I want to revoke it. No, because you said if you're going to revoke it, you're going to revoke it in 24 hours. You've already said when you're going to do that, so you can't trick them and revoke it in between time. That's going to be that revocation is going to be invalid. Now also, or if the letter says it's irrevocable, then it's not. Then you can revoke it, as well as perhaps maybe even if the offeree receives the letter or the offer and is thinking about it and then starts relying on it, starts doing things that is reliance on it, that they put value already in almost accepting it, then at that point maybe the offer cannot be revoked. Now, for instance, if an easy example of this is if I'm going to send I want to offer you this pen for $1, I send you the offer, and then you wire me the money of $1. Now at that point, I said, well, I already sent you the money. I didn't formally accept it, but it can be implied or inferred that my sending you the $1 was acceptance. So therefore, you can't send me the money back and withdraw your offer because I already did something. I already acted in reliance of your offer to my detriment. I sent you the $1. So that's in reliance to my detriment, so you cannot revoke it anymore. So just that's another way to basically they already accepted it. let's move on to the next slide and keep chatting about this. Jumping on here to slide number 13, we moved on from offer. Now we're going to discuss a little bit about acceptance. Now, an acceptance can be made by a statement, if you know, it can be or written or oral, or by other conduct. As I mentioned just previously on the other side, perhaps maybe an acceptance can even be already doing something in furtherance of an acceptance. As I mentioned, if I wanted to sell you this pen for $1, and I sent you the offer, if you're already starting to move and already spoke to the bank and already wired me $1 from your country, then I didn't formally accept it or email you or sign a contract or sign the proposal or sign the invoice, send it back to you. I just sent $1. That conduct can be looked at and can be said that is a formal acceptance. Now it's important to note that silence or inactivity, that is not considered an acceptance. So just sitting on the offer and not doing anything, the CISG is not going to consider that to be an acceptance. And now the CISG language, it's going to play an important role, because in there it's going to say, it's going to interpret offers and acceptance, what should be an offer, what should not be, and what is not considered an offer, and what is. So those rules are going to outline the offers and acceptances. Now, in cases where any usage or practices agreed upon by the parties suggest otherwise, silence or inactivity can be interpreted differently. Again, here in the U.S., it can easily be said, if you just sit on the offer and you're quiet and don't do anything, that can easily be interpreted as you're not accepting my offer. However, when practices, we don't know the practices or or agreements by all nations around the world, so it can suggest otherwise, that silence or inactivity may be interpreted differently. So when countries are dealing with each other and attorneys are drafting for that country, they have to know the culture of that country, of what does silence or inactivity mean for those individuals or for that culture when they make an offer. That has to be agreed upon or noted in the contract in the CISG if you want otherwise, if you want inactivity or silence to have some sort of already. If silence or inactivity speaks volumes, then that has to be noted in the contract as well. Let's jump to the next slide. Now jumping on here to slide number 14, but still sticking with acceptance. Now, an acceptance is effective when it actually reaches the offeror, the person making the offer. Now, we know if perhaps maybe things are sent in the mail. When the actual mail is received by the offeror or reaches the offeror, that is when the acceptance has been effective. Now, if an oral offer, if someone's making an offer, is in question, then acceptance needs to be made immediately, unless other circumstances imply otherwise. If there is an oral offer, the more time that goes by between the offer and the acceptance, then it most likely will not be an acceptance, and it would be an invalid, that the time has expired, because oral offers are generally implied that they must be accepted immediately. If someone's saying, I'll offer you this pen for $1 and I'm giving it to you orally, then that generally means I'm making you the offer right now. If you go in and you come back a month later, and it was an oral offer, they're mostly going to say that no, that acceptance is not valid anymore. He made you an oral offer, so it had to be take it or leave it right there when he made you the verbal offer. Now, in some instances, as you know, there's going to be a fixed time when you're allowed to make the acceptance. Basically, there's going to be an expiration date for the offer, which I would encourage everybody to have. You don't want an offer out there to be just sitting with the offeree sitting there, and they can come back a year later and accept it. You have to put a time frame, and I would also suggest how the acceptance has to be made. You can state it in an invoice. This offer is good for for 30 days, and acceptance must be made by signing the invoice and emailing back to scanning a copy of the acceptance. That's fine. Again, when you're making the offer to another party, the offeror holds all the power, because he is the one making the offer at first. So it's better to be the more language you have on what the rules are to accept it, the better. Now, if there's not a fixed time for the offer, Now, then the acceptance, it's the CISG states that the acceptance has to be made within a reasonable amount of time. That's going to be also up to different cultures. A reasonable amount of time is I'm sure in every culture is not interpreted what a reasonable amount of time is to accept an offer. So the attorneys or the individuals making the offer are going to have to know, if I'm making the offer to a certain other country, they have to know what would a reasonable amount of time be for their culture or their acceptance. Perhaps maybe if I make an offer on a certain day, there's religious holidays, so that they won't make an offer for, if there's a religious holiday that they celebrate for perhaps maybe a whole week or 2 weeks. Then if you make an offer and they come back 3 weeks later with an acceptance, and you know that that country had a holiday, a religious holiday for 2 weeks, and they come back 3 weeks later and accept it, I would say that's still a reasonable amount of time, because you know the business was all the employees, everybody was out on that holiday. So you just have to know what, when you're making the offer, what is a reasonable time to accept it for the offeree if you did not put a definite amount of time. Now, also a late acceptance is not effective unless an oral statement or some notification is made to the offeree. If there's basically some amendment, if I put a timeline, then you would know, if I offer you this pen, however the offer is only for 48 hours. If you come back 72 hours later and accept it, the offeree, the person buying it, is going to have to prove that me, the seller, I basically amended my offer and allowed a late offer to be submitted after my 48-hour time frame. Now, also, in order for a contract to be formed under the CISG, now an acceptance to an offer has to become effective. So we know it can't just, it has to be reached. There has to be a legally binding acceptance. Then we would argue if acceptance was actually made, but that's something for the attorneys to argue, that, if you want to be bound by that agreement, then they show that the acceptance was legal. Now, once a contract is formed, now all the following engagements, anything else happen, they're just going to be interpreted as amendments to the contract, additions to the contract, or updates to the contract, or perhaps maybe layers on top of the contract. But once a contract is formed, then that's the contract. Any other changes are just amendments. We don't actually change the actual contract. We just put other documents on top of that to change the contract. Well, let's jump on to the next slide, and almost done, guys. So let's keep talking about this. Jumping on here to slide number 15, consideration. Now, as we know, in the common law in our courts are seldomly or are almost never going to just enforce a gratuitous promise. Basically, they're not going to really enforce a gift. Now, this means that that a promisor, it doesn't need to carry out all the terms of his or her promise to somebody unless that other individual has paid a price for that promise. Now, if I'm just agreeing to give you, $10,000, yeah, okay, I promise one day I'm going to give you, tomorrow I'll give you $10,000, and there was no consideration. You didn't pay me, you didn't give me any consideration, you weren't going to give me any products or anything like that, then the courts are not really going to enforce me to give you the $10,000, because there was no consideration, there was no payment, there was no other burden. I'm burdened by giving you that, but I wasn't getting any benefit, just pure burden. You were just getting pure benefit. Then the courts are hardly going to hold that as an actual agreement. But this type of consideration for the contracts must be held in order for judges to say that is a valid contract. But because the CISG, it's generally for the sale of goods, so they're gonna always automatically think all the time, or see that consideration does exist because it's goods, because you're actually given a product, a hard tangible item, and there's always a price to it. So consideration is going to exist because there's going to be no promises. The judges don't have to see as well, did somebody give up something? Was there really something of value exchanged? It's going to be pretty clear because it's going to show the invoice. This is the CIHs for the sale of goods. So just taking that for the sale of goods, that means obviously there's going to be money and there's going to be goods exchange. So in that case, consideration is always going to be met, or at least 99% of the time, consideration is going to be there because these companies are not giving stuff away for free. Either they're paying for it or they're giving a product away. So consideration is seldomly is going to be a problem on this CISG contracts. All right, let's jump to the next slide. Now jumping on to the last slide here, number 16. We're almost there, guys. Just touching on the writing element of a contract. Now here in Texas, as we know, there are certain contracts that or certain agreements that have to be in writing. For instance, the sale of land here in Texas, in order to be bound by a contract, by an agreement to sell land, that has to be in writing. So for instance, if I'm going to sell you a piece of land or a home and we agree to the terms, that cannot be oral. That in order for Texas to enforce an agreement for the sale of land, it must be in writing. That's Texas law. However, the drafters of the CISG accepted the notion that when the writing requirements frequently make, especially international contracts, very, very slow. As we know, there's language barriers. So if people want to change certain things dealing with large amounts of contract, we know there's large law firms and there's large contracts. Now, here, because of that, because of the timeliness, they did know that the CISG states that contracts, they do not need to be evidenced by writing. So meaning verbal contracts will be enforced as well in the CISG. I know it's something that I was reading out and knowing when I first thought about it. I thought, wow, it's amazing that contracts between these large multinational companies dealing in multi-millions of dollars with huge amounts of products, I would first think like, oh, you know what? Yeah, those type of contracts, they have to be in writing because they're dealing with so much money and things like that. But the drafters, they didn't want the agreement, these parties to be slowed down, because sometimes the bigger they are, the slower things move. So they didn't want the companies to slow down trade. So that's when they said, you know, these are all CISG, these are our guidelines, but the actual agreement does not have to be in writing. So I just wanted to make sure that was something that you guys knew, because I think it was very interesting and very important. Okay, well this was the last slide. Let's this was the last slide with subject matter. Let's go on to the last slide and finish this up. Thank you. Hey guys, thanks. So thanks for joining me. I just wanted to let you know, thank you for the slide. These slides are going to be posted they're posted on Blackboard right now, so you should have them to follow along. If you did have any questions on this video or anything, feel free to shoot me an email and I'll answer what I can, or perhaps maybe we can discuss it in class as well. This last slide, I didn't want to know. I know I mentioned it last time in class, but just so you guys have it, or for anybody who was not able to come last class, we will not be having class on Monday, October 21st. So that class, we're not going to have class in person. I'm just going to record the lecture, same thing like I'm doing now, and it's going to be emailed to you in the same link, same YouTube link for you to watch it. So again, Monday, October 21st, we will not be having class in class. I will email you the link with the lecture, same way I'm doing now. Okay, well, thank you very much, guys. Hopefully I'll see everybody next week. Thanks, guys.